I hereby introduce to you Mr. Michael Veazey.
Hi, welcome to Amazing FBA. This is your host, Michael Veazey speaking, and this podcast episode is brought to you by Reliable Income, led by Adam Hudson. Reliable Income is an Amazon community and course, and Adam Hudson is an Amazon seller. He's doing well over 7 figures a year now, and also a very straightforward Australian. And in a sea of hyper Americans, that is quite a refreshing change. Adam will tell you it straight when it comes to how much money you need to private label, which is measured in the thousands of dollars these days, not the hundreds, and how long it takes to really get a private label product off the ground when you're working alongside the day job, which again is measured in months rather than weeks. Now, alongside that, Adam, however, is a very, very positive guy, and he has a lot to offer in terms of getting a really great positioning on Amazon for your products. So high quality products selling at a really good price and keeping the competition at bay, which it's never been a smarter time to adopt that strategy than in 2018, when Me Too or Cheap are just going to be trashed by the Amazon crowd or have their price disappear into the floor overnight. So I really, really think his approach is sustainable. Hence, I think that Reliable Income is a very good word for his type of training. If you want to find out more about Adam, as I said, amazingfba.com/Adam. If you want to find out more about his training and or take the 4-part video training course, which is free, go to amazingfba.com/reliable, RELIABLE. Just for more transparency, I am an affiliate of that, so that will buy more than a coffee, as is the traditional affiliate sales. But what it will do is help cover some of the costs of running the podcast, which hopefully benefits you. Some of the software that I have to use to keep in touch with the guests, and my beloved and long-suffering editor, Daniel, who is worth his weight in gold, but I have got to pay him because even editors have to eat as well. So I've got to pay for blogging, podcast hosting, the rest of it. So that helps to cover some of my costs there. And I hope you'll check that out. Now on with the show. So good evening and good morning, wherever you are in the world. This is Amazing FBA, and this is your host, Michael Veazey. I'm here with 2 young gun paralegals from the Amazon Sellers Lawyer Group, which is run by CJ Rosenbaum, who we've had on the podcast and is a very expert guy, and he's bringing on some other very expert people to talk to us today about the thorny issues of IP, that is intellectual property, which can work on 2 sides of the equation that we're going to talk in 2 different episodes. One is going to be how we get ourselves back on track when there's an allegation of intellectual property infringement against us. But to start with, we're going to start with the whole question of how you protect your own intellectual property. So I'd like to welcome to the show Rob Segall and Travis Stockman. Hi, guys.
Hey, everyone. Good to be here.
Excellent. Good to see you. So, Rob, we're going to deal with your area of expertise first. So would you like to introduce yourself? Just give us a very quick flavor of who you are and what brings you to this point.
Hey, everyone. My name is Rob Segall. I am a 3rd-year law student here in New York. I've been with the team at Amazon Sellers Lawyer since 2015 when I started going to law school, and I've been here ever since. I love working for Amazon Sellers Lawyer because we get to be by the beach. I live here also, and the best part is that we get to help sellers who work across a slew of industries, and we get to help entrepreneurs who all do different types of things.
Great. That's great. And Travis, we'll talk to you in detail when we get to your episode. So, Rob, tell us first the basics for those of us who aren't lawyers. What is intellectual property, and what forms does that come in for Amazon sellers?
Sure. So essentially, intellectual property is exactly what it sounds like. It's something that's created within the minds of an individual. In terms of a copyright, it's considered a creative form of expression. It could be a book, a motion picture, a poem, stuff like that instantly becomes copyrighted in the US upon its creation. A trademark is used to identify the source of a product. You get a limited monopoly essentially with a trademark when you develop a brand that becomes associated in the minds of consumers. Just like the Nike swoosh identifies in the minds of consumers the Nike brand, could happen with any trademark for any Amazon seller as they develop their brand on the platform. And with patents, it's basically a limited monopoly for an invention or process, things along those lines, which one encourages innovation by disclosing the invention to the public, but also promotes competition by motivating others to improve upon the invention so that they can get their own patents and expand the industries that they're working in.
Great, thank you. Well, that's a nice, clear explanation, especially from a lawyer. So it's good to know that you're continuing CJ's tradition of lawyers who actually speak English. And the other thing is two things that spring out to me from those definitions. One is the word monopoly, which is obviously from a seller's point of view a highly desirable thing, and anyone who's played the board game by the same name will know that that's how you win, is like, you know, basically dominating the space, which is, I think, an important mindset to go in with when you're going into Amazon in 2018. And the other thing you're talking about is the idea of competition and improving on what's already out there rather than just copying what's there, which again, I think is a very big hint for all of us, not just within the legal sort of way of looking at things, but as a good business practice. So tell us, first of all, then, what is the simplest form of intellectual property that an Amazon seller is likely to deal with, and how would they go about knowing that they've got something worth protecting, and then how do they go about protecting it?
Well, I would start by saying that nothing is simple with the Amazon platform. It's a beast in itself, and it's sometimes unpredictable. So calling anything simple with Amazon is probably a no-no. But that being said, any seller, when they create a listing and they create their own product detail page and bullet points and all that, if that's an original form of expression for them, that's technically copyrighted in the United States. So in terms of simplicity, that's the simplest creation of intellectual property rights, but with enforcement, it can definitely be more than simple.
Okay, so basically, if I understand correctly, and under the American legal system, if there is such a thing, I mean, I know there's state law, there's county law, there's federal law, but to put it in simple terms, that if you create something new and you put it out into the public domain, that you basically have some kind of copyright over the form of expression automatically. Is that correct?
Essentially, yes. Any original creative form of expression put into a tangible medium is considered a copyrightable subject matter. So when a seller creates a listing detail, it goes up on the web page as a tangible medium, and that original form of expression, the description of the products using those unique terms and words, becomes copyrightable.
Okay. So when you say copyrightable, you could copyright it. Does it mean if, for example, I write an Amazon listing that I spend possibly money, I employ somebody for a few $100s, I mean, the standard fee out there seems to be around the $500 mark, to do some serious customer avatar research, i.e. who buys your products, to do some keyword research, to look at the benefits and downsides from other reviews, and then to create a crafted listing. If I do all of that and I put it out there, do I have the right to go after somebody who copies a whole or part of that listing? And if so, Correct. How does that work?
Copyrights are created once the material is put into a tangible medium. Unlike a federal trademark, they don't need to be registered to have force, but you can register them on certain websites as well to strengthen the protection.
Okay, so you have basic rights without registering, but registering is a wise practice if there's a lot of value in it. Is that a fair summary?
Fair, yes. It memorializes that your copyright has been in use and gives you that priority.
And if I can jump in really quick, one thing Amazon sellers have to realize too is when you create this page, especially as the brand owner, you grant the perpetual license to use that image and description. So if somebody joins that listing, essentially you've provided the image, you've provided the description, that wouldn't constitute copyright infringement. But if I created a duplicate ASIN using the same images and using the same description, that's the point where it becomes an infringement.
Okay, thank you. That's very, very worth knowing. So for anyone who's doing retail arbitrage or anything related to selling an existing ASIN on Amazon, your listing is not a sort of a sacred thing as somebody else can leap on it and not offend against intellectual property laws. Yeah. But as soon as you've got a new listing, that's a different thing, right?
Right.
Correct. The replication of the existing material would be the infringement.
Okay, that's worth knowing. Fantastic. So thank you very much for clarifying that. So it sounds like we have a certain amount of built-in protection for copyright for our listings, which obviously has a financial value, both in terms of the fact that you might have paid somebody for it, but also because it can affect conversion rates and thus the sales rates. And over time, it becomes an asset in itself, right? Now, let's look at the actual product itself. First of all, let's talk about trademark, because I have the feeling that it's simpler than patent law or patent law. So tell us about trademark. Does that automatically apply if I create something and I call it, Rob's legal folders, and I start selling little leather binders to put legal things in? I don't know if you guys use that. I think British lawyers tend to wander around with leather satchels. But if I created something like that, and I just put it out on Amazon, do I have any kind of existing protection, or do I need to file something, or what happens then?
Essentially, a trademark is designed to identify the source of a product and prevent consumer confusion. When we say consumer confusion, we wouldn't want people to go into the store and see 5 types of cola, but not be able to distinguish which one is Coca-Cola and which one is Pepsi, which one is the store brand. Because then Coca-Cola would have no motivation to market their products, to advertise, etc., because consumers wouldn't be able to tell the difference. So on one hand, the trademark is designed to protect a consumer so that they know what they're getting, they can associate the quality of the products that they like, that they enjoy, but also to protect the brands and encourage them to improve their products and do things that associate them in the minds of consumers.
Okay, so let's bring it back to very simple things. Let's, for example, decide that I get this mug and it's got a design on it, which this may be even infringing copyright to even put this on my show, but I doubt that their lawyers are going to be watching. It says keep calm and play piano. So presumably that would automatically be copyright if I've stuck that out there. Is that right?
Assumably, yes, it would be copyrighted.
Okay, now let's
your original creation.
Okay, let's assume that by the way, just to be clear to the lawyers of the Keep Calm and Play piano mugs, no, I'm not claiming that I created this, because obviously I didn't. I can't see any trademarks under it, but imagine that I've written in somewhere like Mike's Magical Mugs somewhere here, and I've decided that I want this to be the name of my company. I bought the domain name, and I want that to be my trademark. I'm presuming from what you've just said that the letters, assuming that the form of writing and the design, because I've just put it out there, is copyrighted, but my trademark isn't covered yet. How do I get to the point where if somebody else uses Mike's Magical Mugs, then I can go after them and say, oi, you can't do that, and send a cease and desist letter or go via Amazon system?
So there's 2 types of trademarks in the United States. One is under what's called common law rights. Common law is basically the adoption that the United States early took on and created based off of English law. But there's also federal trademark rights, which require registration with the United States Patent and Trademark Office. Common law rights could be established by doing what you said, which would be putting a logo or a name on a product and selling it and using it in commerce. If you were to register a trademark with the USPTO, you would automatically have proof of that trademark's validity. However, if you only have common law trademark rights, which are essentially argued by yourself that you have created these rights by marketing and selling the product for a period of time, it's much harder to enforce those rights because there's no governing law that says that these rights have been created and are enforceable.
Okay, so in a way then you have theoretical rights straight away, and in practice it's harder to enforce, so you're better off getting it registered with the USPTO. Is that a fair summary?
It wouldn't be necessarily straight away. It would be, you would be able to argue after using your brand for a little bit without going to the USPTO. But the best
so the length of time
for sellers is to use the USPTO system and register their trademark.
Great. Okay, so that's clear. So the length of time has an effect then. So if I've got something out there effectively being used as a trademark, then the common law argument is stronger. Is that right?
Correct.
Okay. Tell me about then the more straightforward and, as you said, the recommended approach, which is to register it with the USPTO, which is what does that stand for? The United States Patent Trade Office or something like that?
Yeah, it's the United States Patent and Trademark Office. So when you want to register a trademark, there's the first consideration is usually what's called the strength of the mark, which is discussed on a scale of distinctiveness. So the most distinctive marks are the most readily registerable types of trademarks, meaning that they'll require less proof of secondary meaning and use in commerce. Essentially, arbitrary trademarks such as Kodak, which are basically made-up words, are easily registerable once they're used in commerce because there's no confusion that they could be what's known as a descriptive trademark, which could be Rob's magical, coffee mugs. We would have to prove that that has more of a secondary meaning in the minds of consumers because it's generic, it's a name, it's magical, it's just like a commonly used term. And coffee mugs, a lot of people sell coffee mugs. Whereas if Kodak cameras, that's a made-up word, the USPTO is more likely to just grant it based off proof that that brand is being marketed and used in commerce. So
very interesting distinction. Thank you for clarifying that, because I'd never really understood why people go for strange made up words. And it's one of those brand decisions that you have to make from a marketing point of view is, does my brand just describe what it is, like Mike's Magical Mugs or whatever it is, or is it just a 6-letter made up word? And now I can begin to understand why, from a legal standpoint, for the trademark point of view anyway, you might go for the made up word thing.
So when you're registering a trademark, you need to evaluate what class of goods and or services you want your mark to apply to. There's roughly 50 classes in the US system to choose from, and within each class there's several subclasses. For example, there could be electronic machinery, and within that there could be food blenders, food processors, and other related subjects, but there could also be machines used in a woodworking situation where it's completely different. So within each class, you need to also identify a subclass. The purpose of this is to allow protection in certain industries without granting an unfair monopoly across the name or use of a word. For example, there's the company United Airlines, and there's also United Healthcare. United Healthcare is assigned to a class which is likely for healthcare services and related products, whereas United Airlines is likely in a transportation and aviation products category. Both companies are permitted to use the United trademark within their respective industries without infringing on the other person's mark. So on the Amazon platform, we can have sellers who are using similar names, but we're selling completely different products without infringing upon another.
Great, thank you. Well, that's really, really clear, and it's very helpful to know that it's not just about a name or even a physical mark or a logo, but it's also about being within a certain sort of commerce space as well. So that's very, very important distinction to know. So tell me a couple of things. First of all, since I mentioned it about the difference between a logo and a name, how easy or how different is it? How does that all work out? So if I want to go for Mike's Magical Mugs, for example, and that's the name, and then I decide that this, obviously I'm not doing this Mike's Magical Mugs Lawyers, but if I decide this little crown here is the logo for the company, how do those two things relate? Do I have to register them separately? Are they kind of bundled in together somehow?
It would be a separate registration. So there's two types of trademark applications in the US system. The first would be what is called a word mark, which is exactly what it sounds like, just the word itself. So if it was Amazing FBA, it would be Amazing FBA. It's not necessarily how it looks, just how it's written and the words themselves. Word marks tend to provide a bit stronger protection than what we're going to discuss next, which is picture marks, because they strictly identify the brand and the products that they relate to, and there's less opportunity to argue confusion based on the imagery, etc., font, which is used within the mark. Word marks are important as well. I'm sorry, picture marks are important as well because they provide an additional layer of protection for your brand. For example, the Nike swoosh is probably one of the most valuable trademarks in the world because immediately when people see that mark, they know where those pair of sneakers came from. But picture marks, especially on the Amazon platform, do not provide as much protection, mainly because if you're interested in registering for a brand registry 2.0, which is Amazon's newest system for enforcing trademarks on the platform, they require a word mark registration within the country that you are selling in. And without that, it's impossible to get signed up for Brand Registry 2.0.
Okay, interesting. So really, it sounds like wordmark is both on the Amazon platform, the most important and indeed essential if you want brand registry and intellectual property protection, and is the easiest to enforce legally. So it sounds like that's the one to go for. And then the picture mark can be an additional and important thing, but not quite as crucial. Is that a fair summary?
That's fair, yes.
Good. So thank you for clarifying all of that. Now, let's talk about costs. Obviously, these things are going to vary. It could be how long is a piece of string, but what sort of money are we looking at for trademark protection? Are we talking tens of thousands of dollars or $10 or 100 or 500? What sort of level are we looking at?
It depends. The USPTO calculates its fees on a per class basis. The fees per class range usually between $225 to about $300, usually somewhere in between. So if you're filing for protection in 3 classes, you'll be charged that fee times 3, plus whichever law firm you use is time or flat fee for that work. But
okay, so that's per
hundreds of dollars to $1,000 range for the USPTO fees.
Sorry, I'm interrupting you at the precisely wrong moment. But so if you, for example, if I want Mike's Magical Mugs to be in the subcategory under, say, whatever it is, crockery or something, and then in kitchenware and drinking utensils and something else, that across 3 different classes, then it's going to be about $300 per class plus a bit of legal fees as well to get that to happen.
Correct.
Okay, well, that gives me an idea. So really, trademark is quite an affordable form of intellectual property protection from what I understand. So let's move on to the famously treacherous waters of patents or patents, however you say it. And even in Britain, we can't agree how you say it, let alone across the Atlantic. So tell me about patents and what is it and how does it work for a person who is trying to protect that patent?
Sure.
Oh, patent.
So in the United States, there's 2 types of patents. The more common type of patent is a utility patent, which is to protect the function of a product. And there's also something called design patents, which basically protect exactly the way a product looks. Utility patents certainly have more strength and are more enforceable and are easily enforceable on the Amazon platform because patent laws seems to be taken more seriously by the platform in our experience. To create a clear, different picture of the difference, basically the way a product functions is, what it does. So we could have a client who makes a ring for holding nail polish, and it could have a certain appearance, a circular shape that the nail polish goes in so that whoever's painting their nails doesn't have to hold the bottle while they're painting. If our client had a utility patent for that idea and that invention, even if somebody took the circular design and changed it to a diamond and started selling the same product, because that product performs the same function, it would infringe the utility patent. If it were merely a design patent, changing the design of the product to be diamond, square, rectangle, whatever, would avoid the infringement of the design patent. That's why most people would rather have a utility patent if possible, but utility patents are also much harder and more expensive to acquire.
Right, I was going to ask about that. So it does sound like a utility patent gives you, you were talking at the beginning about intellectual property and its function, and one of the functions from the point of view of a seller or the owner of the intellectual property, in this case, the form of intellectual property being patents or patents, that it gives you that kind of quasi-monopoly thing, I guess, more easily with a utility patent. So you can dominate, for example, the market for nail varnish bottle holders, which I imagine could be worth billions because I guess there are a lot of nail varnish bottles out there to be held, right? But so how hard is it to get this? It's obviously going to be harder than just a design thing because it's bigger and potentially more valuable commercially. And what steps do you have to go through to get that?
Well, to obtain a patent, it first of all usually costs tens of thousands of dollars. Patent lawyers are required to sit for a separate bar exam in the United States, which the last time I checked had a 35% passage rate. So it's a real tough exam. And in order to apply and register someone's patents, you need to be one of those attorneys. Currently, we only work with enforcing patents and helping sellers defend and litigate their patent rights. But we work with local counsel who can help sellers who are interested in obtaining their own patents as well.
Okay, so it does sound like for most people, or certainly for those starting off on a budget of a few $1,000s, a few £1,000s, or even euros, then that's going to be pretty much out of our reach, I think. So I guess you're going to be doing that sort of thing when you're looking at a market that's going to be worth a very significant sum to you each year, right?
Correct, but if you think you have a $1 million idea, it might be worth the investment in the beginning, or look into other sources, investors to help you get that, because it will help you create that quasi monopoly and allow you to build your product and brand together with a trademark from the outset, rather than having to worry about someone stealing your idea.
Yeah, that does make sense. And I guess you've got to make that business decision of the risk reward at a certain point, a sort of tipping point where you think this idea has got value. And unfortunately, I guess by that point, the rest of the market may have woken up to that and nicked your idea. So tell me about that. Does that relate in the same way that with copyright, you just put something out there and there is assumed once you put it into concrete or tangible form, I think is the word you used, that you basically have automatic copyright protection. With trademarks, there is a sort of common law protection that gets stronger over time, or you can file, you can file about that. What about patents or patents? Is there a way that you get any kind of given protection if you've been trading for a while with your own kind of design? Or is that purely just when you register it, and otherwise you can just lose all the rights to that?
Yeah, as far as I know, patents are only acquired by registration. It's in the United States, patents are assigned on a first to file basis, meaning that if if Travis and I invented the same product, and he invented it before I did, but I took it to the USPTO before he did and acquired patent rights, I would actually acquire the patent rights even though Travis invented the product before me.
Yeah, there have been some very famous cases of that. I seem to remember that sort of Alexander Bell, who was actually a Scotsman originally, but was one of the most famous American inventors, had a bit of an argument with somebody about who invented the phone first and who got the rights. And I believe also the electric lights and Edison were involved in similar discussions. But tell me about the difference. Is there much of a difference in price and difficulty between the utility patent, which we talked about, and the design patent, or are they both the same sort of costly, difficult procedure?
Design patents are substantially less expensive and the process is usually faster. But as I said, our firm has never really filed for design patents or utility patents. So although we know the time frame is different, I don't have personal experience to speak of.
Okay, that's fair enough. Well, the last area we were going to just touch on, I think, is you were talking about international protection. And obviously, above all, with Amazon, we are dealing with, I guess, apart from selling to the United States, which although this podcast is aimed very much at British listeners, a lot of the YouTube viewers are American, and the blog is sort of 50-50 as well. A lot of people are going to be selling in the UK as well, and maybe Germany, possibly France, Italy, Spain. And then there's also the issue of having protection when your product is in China being manufactured. So are those areas that you help with, and can they be bundled together? Does everything have to be dealt with in a separate basis in each and every country?
Sure. Yeah, we do help with intellectual IP enforcement in some ways. We've helped sellers respond to complaints submitted against them on other platforms, but I'll let Travis touch more on that later on. We also have worked within what's known as the World Intellectual Property Organization for trademarks. This system allows sellers who have existing trademarks in one jurisdiction to apply to have their trademark amended to apply with the WIPO in other jurisdictions. For example, if we have a client who has a US trademark, we can apply with WIPO to have that trademark apply in other countries like the United Kingdom, Japan, China, Vietnam, India, where we like to encourage clients to register in countries where there's going to be manufacturing hubs and more of a likely need to enforce their rights there.
Okay, that makes a lot of sense. So are we talking about patents only, or does that also include trademarks or copyright of images or words?
I'm speaking more specifically about trademarks. That's the process I have the most familiarity with. As far as that goes, the most important thing to consider is that if someone in China is ripping off your trademark in the United States, you can try to get Amazon to take action. But if Amazon doesn't take action, or they're doing whatever they do overseas to create hundreds of Amazon's accounts where it doesn't matter if we're getting them suspended every day, there's nothing in U.S. law that's going to force someone who's in another country to come here to defend themselves against the claim. So if you register your trademark or your patent in another country, you can then not only start the process with a cease and desist letter that says, hey, here's our Chinese rights, or here's our UK rights, or here's our Vietnamese rights, and we're going to come there and sue you if you don't stop. But then you actually can if you want to. And our firm could help you find local counsel in China or the United Kingdom, and we can bring the fight to the seller who won't stop.
That sounds quite powerful to me. As you say, that the main thing that always strikes me is if somebody's offending against US law, even if it's a UK seller, never mind somebody in the never land of China, where normal legal principles sometimes feel like they don't apply. And I'm not sure that's probably not true, but it doesn't feel like it from a UK or US perspective. Then, yeah, it does feel like you never got any leverage over them, if you like, or any hold over them. But the idea that you can get it enforced by their laws of their own country is a very attractive one to somebody who's suffering that situation. Is that when it comes to trademarks, which sounds like the more affordable and straightforward option out of these things, is that a very expensive process to go from several, say, $1,000 to register one trademark across 3 different classes in the US? Are we looking at thousands to register internationally, or what sort of price tag does that come with?
I'm not exactly sure on the per class fee, but it's a similar structure to the regular United States trademark application process, where it's a per class fee and per country. So it'll be, you know, per class and then multiplied by how many countries you're applying to.
Yeah.
Some countries have caveats with small additional requirements to finalize the registration, but it's usually a straightforward process that could be handled within several months.
Excellent. Well, that's a reassuring thing, and I guess that in practice, that, for example, in my case, I get stuff manufactured in China, and that's pretty much it, and the bidding of stuff in UK, which sells in the UK, so I could focus on the UK, US, Germany, and China, and know that I've covered all my bases if I have something which has intellectual value, you know, which has a commercial value and has an intellectual property aspect. So that's very reassuring to know. So Rob Segall, thank you very much for your help on protecting existing IP, and also how straightforward it sounds, relatively affordable to get into trademarks. And that sounds like something that all of us should take a bit more seriously, really.
All right. Thanks for having me.
Thank you.